Good afternoon, everyone, and welcome to the session on what are the different challenges around labor law in the current scenario of the lockdown. And I believe a lot of challenges are around the labor law stream. And I have my friend, like dear friend with me today, Nitish, who is a practicing advocate. Is Nitish, are you Nitish there? So to begin with, due to this lockdown, a lot of things have changed in this scenario, where this new culture of work from home and has developed like altogether, and some of the organizations had uh, yeah. There are a lot of things that are happening, like current situation. Like work from home is one good example. And today in this session, I have a lot of questions in mind, which I'll be putting forward to Nitish, who is a practicing advocate and has been dealing with a lot of labor law cases. And so work from home is one. Then there are layoff conditions, and there's retrenchment, and there's sexual harassment issues that are to be dealt with, and a lot more things that I want to discuss in this session today. Let me just introduce everyone with Nitish.
Yes, hi Mayur.
Yeah, so now you are clearly visible. And let me just introduce Nitish to everyone. Nitish is my best friend from college, and he has been one of those who has, accelerated his practice like anything. He started off from Rajasthan High Court at Jodhpur, and now he's having his own independent practice in Jaipur. He he has been a panel lawyer to a lot of government organizations, as well as he is representative the Rajasthan state at Supreme Court also, as well as he is somebody who has more than 3,000 cases on labor law for a media company, and for obvious reasons I can't name that media company here. But I would just want Nitish to start with a short introduction about the session today, and then we can go ahead with it. Right. So Nitish, can you please let
Hi
us know
Mayur,
what
and
has
so
has
first of
changed?
all, flabbergasted with such a introduction. You cannot expect such good words from your best friends. You always talk a language of sarcasm between friends. But nonetheless, thank you so much for such a great introduction. See, in this session, we'll be talking about more of how the labor laws will be dealt in the current COVID situations, and what are the basics of the labor laws which need to be looked into in the current aspects, and how these laws have evolved over the period of time. So basically, labor law is a social welfare legislation which had its beginning from the constitution. Labor laws are of three types. One is that labor law which is enacted by the central governments, and it is enforced by the central governments only. Second is which is enacted by the central government but enforced by both central government as well as state governments. That includes the major part of labor legislations, which includes Industrial Disputes Act, Sexual Harassment at Workplace Act 2013, Payment of Wages Act, and other. There are other 13 more legislations into that list. And lastly, the legislations are which are enacted by the central government, and enforced by the state government. These are basically the laws which are related to daily working as well as holidays and remunerations of laborers. And there are in total around 51 legislations pertaining to the labors and industrial disputes across India. Uh, in 2009, there have been a proposal of scrapping these all 44 to 51 laws and introducing four main legislations, which are Code of Wages, Code of Industrial Relations, Code of Social Benefits, and Code of Safety Hazards. But these are still yet to come into picture. So as on today, when we speak, there are those 44 to 51 legislations are already in place, and are applicable across the country. So we'll be discussing how many we can discuss depends on what are the questions across from the viewers and what are your questions. So I've given you a basic
Right.
overview of the labor laws in India.
Right. So the question and answer part from the viewers angle, we'll take it at the end of the session.
Sure.
And for the beginning, let's just start with layoff. What's the situation in the current scenario for layoffs that are taking place? How I put that question across is that recently I was talking to a friend, and he told me that there is a notification out in the southern states of India, like Kerala and Telangana, Andhra Pradesh. There's a notification that people cannot lay off people as of now. The organizations, they cannot lay off people as of now, and whatever is happening, those will be the paid leaves that the employees would be getting. So,
Yeah.
what is the scenario there? How much of that notification is actually, I mean, could be, practiced in the current scenario and all those things? So, to begin with, like layoff.
See, the point is that in relation to layoffs, the notification, the central government has only issued advisory from time to time in last two
Right, as
weeks.
advice. Yes.
Yes, advisory is a general directions in nature. It is not something which is a compulsory adherence to. Yes, most of the companies do follow the advisory of the government, but look, depending on the circumstances of each and every industry, it can be molded into the best industry standards. First of all, the state governments are the agencies which will issue guidelines or which will issue directives regarding layoffs. Layoffs has to be understood in a very wider term. Normally, what we understand from layoff is that there is a mass reduction of the laborers or the workers from the industry. However, layoff is normally of two types. It is first that layoff certainly, because sometimes it is of definite period. So the industry is supposedly facing crisis, so they can ask their laborers to not work, or they do not require that workforce for another, say, 2 months or 3 months. That is a temporary layoff. But yes, when laborers or workers or workmen are removed in large, that is a layoff practice. The government so far has, as far as I know, they have only issued certain directives or advisories. Those are not compulsory in nature, but yes, looking to the humanitarian forces and the situation in current times, people are adhering to those advisories. But you have to understand that you need not necessarily be, if you supposedly there are 10 workers who are a deadwood in your organization and aren't giving a productivity either with the times when your industry was full-fledgedly working, then you certainly have the right to terminate their services as per their employment contract or do a layoff. A layoff. So in that practical sense, layoff has to be construed as a very wider term. I have seen many of my clients also giving me queries that there are certain directions or orders by the government. You have to see that those are not the orders; those are the advisories. Yes, as far as possible, if you can accommodate, you should accommodate, and you should take care of your labors. If you care for your people, the people will care for your industry, in that logic. But supposedly, if you are really facing crisis, and keeping those extra workmen would result in closing of an industry, there is certainly no point of keeping it. The first and foremost target of any business entity or a industry is to protect its business. So basically, it has to be construed in that sense. It is not necessary that that if you have already planned supposedly for 2 months in January or December, you have planned that post the financial year is closed, you will be removing, say, 100 people from your industry as there are introduction of some new machines, or you are not producing a particular product that has become obsolete in the market. You can still go ahead with that.
Right. So what happens to all these startups, Nitish? Like there are startups around, right? and because of the lockdown, they are not getting business. So they don't have money to pay to all these employees and all those people. So how do they go about all of this? Right? I mean, they don't have a choice altogether but to lay off these people because they are not able to give them salaries.
Correct. So these are tough times. We have to admit that these are tough times. As I answered in my layoff question, these are only the advisories. If an industry is threatened with a position that the whole unit or whole business house will get scrapped, following the advisory of the government, you cannot follow that. You have to, go ahead with the best industry standards or best industry practice. If the industry practice says that, in the times when a proper technique or a proper product becomes obsolete, you need to lay off certain people from your industry in order to keep the sanctity of that industry, you can go ahead with that.
Right. Okay.
Because see, startups are basically funded business houses. So in order to, they are
But
also
not
the
all
management
startups
of
are
the
funded, right?
Yes, correct. So all the management of these startups are also answerable to their investors, and the answer to the investors is only to show what is the productivity and what is the profit margin. So in order to sustain an industry, you have to take a hard step. Unfortunately, yes, these are hard times. Everybody is suffering the wrath of the time, but that is only the way out. You cannot, you cannot cannot take the blame on the industry itself. Yes, had it been a good time, people would have been employed, people would have been still working in that industry. But now, still, since the industries are locked down, we do not know when the lockdown will open. In that scenario, the rules or the business houses internal working practices should be followed.
Right. So again, like there's an ray of opportunity also there for
Correct.
especially for the advocates practicing in the labor law field. Can there be a recourse action where all these employees who have been laid off because of such a situation, can they claim some sort of compensation from the startups or let's say these industries who are laying them off?
See, every
There's an
bad time
opportunity there.
create good opportunities. I very firmly believe that every bad times create some very good opportunities. In maybe in different sectors, but it definitely creates good opportunities. So exactly like you said, as a labor practitioner, people can see a boom in practice in next say 6 months. Normally, what happens is that the recourse of industrial of the labor laws goes to the labor courts. So I sincerely believe that in another 3 months there'll be a huge rise in labor cases, because the persons who have been laid off, retrenched, or terminated from their services will be filing a labor disputes to at least gain some financial benefits out of that litigation. So I see that I see that a lot of litigation will be brought into the market in another say 6 months or 8 months,
Right. And
because
that would be from both the sides, I believe, from the
yes,
employer
yes,
side as well
certainly,
as from the employee
certainly.
side, right?
See, the Industrial Dispute Act is the provisions which is applicable. Most of the provisions or majority of the provisions are applicable to both laborers as well as the industry. So supposedly you are acting on say a proper procedure prescribed under the law to remove certain people from the industry, from your organization. Even you have to sometimes go to the labor commissioners and prove your method, that what you have adopted is within the four corners of law, and the all fairness or principles of natural justice have been adhered to. So I see that in next 6 months there will be a rise in labor litigation from both the sides, industry as well as workmen.
So
Industry
that there's
claiming
a
that
great opportunity there then for a lot
yes,
of
yes, yes,
people
certainly.
who can actually make use of this time and learn these labor laws and what is the actual kind of work. That's something we do in our
Yeah,
courses at
and one thing
LawSikho.
is also what Oh, I'm sorry to interrupt you. But the point is that labor law is also vast. Suppose the termination has to be challenged. Some industries, due to financial measures will not deposit gratuity of the laborers, so that laborers will go to contest about their gratuity issues. Their wages might not be paid. Sometimes it happens is that industry is not closed or a person is not removed from the industry, but they are not being paid for 3 to 4 months. So those people will be going under the Payment of Wages Act to obtain their back wages which they have not received. And there are provisions that which says that provisions as well as judgments which says that a penalty of up to 10 times can be levied upon the industry for not paying the wages. So looking to that aspect and looking to the current scenario, I very sincerely believe that there'll be a at least 40% more litigation than it usually happens in the labor courts in the given lockdown situation.
Right. And how much is the system prepared for all of this?
See, very frankly speaking, system is never prepared. System is always underprepared. If the system is prepared properly, then there is no point of litigation ever. There will be never litigation. Never litigation will never happen. So system is always underprepared. Infrastructures of labor courts are very poor. The labor commissioners, the conciliation officers are always less. So as I said, that bad times bring some very good opportunities. So the system is not up to date. So that means that litigation will grow. Hopefully, if you think that that conciliation officers or mediation officers or labor commissioners were adequate in number, you will not see that much rise in litigation. So since the system is not updated, you will see that there will be a good rise in litigation.
Right. So that reminds me, the only time I heard the word lockdown was strikes and lockdowns while I was reading the labor laws in my law school. And
Correct.
now the lockdown has come to reality and everywhere it's a lockdown. So not
At
to
least
waste time.
in our lifetime, we are seeing this for the only time where the whole country is shut down and we are sitting in our respective offices and houses and
Right.
doing everything from work from home. Work from home is also an interesting concept because it is never imbibed in the books of law. There is no concept as a work from home in the four corners of law. But this is something which needs to be understood by the government and has to be looked into in relation to the future prospects.
Right. So the second question I have is like, what happens to these people? There are people who are working in the emergency services, right, and providing all these emergency services to people. Like, for example, I recently came across a news where the nurses of a hospital got exposed to coronavirus and then they were treated and all those things. So what happens in these conditions? Like, what happens to
The
the
essential
workplace of these people, the nurses
See,
and all?
workplace is a workplace. Workplace is the definition of workplace is very extensive. It is not inclusive. When I say that it is not inclusive, it means even if I am supposedly you are traveling to my office in Jaipur on behalf of LawSikho for some task, and you come across some incident, that is also your workplace. So workplace is a very open definition. So anything and everything which you are doing to justify your job opportunities is your workplace. Nonetheless, the essential services, which have been essential services, paramedics, doctors, whatever, whoever are on there in streets protecting us, they are not. Most of them are not laborers. They do not fall within the purview of laborers. Government nurses, and they are within the purview. They are not within the purview of laborers. They are much 2 grade higher than nurses. But yes, certain class of people like the people who sanitize us, they are in the purview of laborers. So most of the state governments have announced packages for their safeguards. There have been instances of deaths of doctors as well as paramedics in the country. So I think the maximum compensation is something around 1 CR per person, and 50 lakhs is the starting which the state governments and the central governments
So
have
they'll be
capped. It depends on
compensated.
state to state. Yes, but most
So
of them
they
do not
all
fall
will be
around.
compensated.
Yes, they have to be adequately compensated. Even the Disaster Management Act gives
Right.
power to the state government to provide them with adequate benefits for their services, which they are doing it in such a bad times.
Mhm. Okay. And what happens to the pay cuts? What is the, exact provisions related to pay cuts that has been happening? Because I also come across a lot of people who tell me that they have not received their salaries, or many of them have received like a 40%, 60% pay cut. What are the exact provisions to this in the labor law?
See, for that you need to look into your employment contract.
Mm-hmm.
Supposedly, if the employment contract gives the power to the employer looking to certain conditions or times to take appropriate measures to reduce your pay, he has all the power to do that. But certainly, it cannot be stopped. It may be delayed. It may be it may be kept on a hang for say another 1 month, 2 months, 3 months. But it cannot be deducted. It has to be given. If they don't pay you your salaries or your wages, there is a specific provisions of under the labor laws, under the Payment of Wages Act, that they can be penalized up to 10 times. So supposedly there is a 30,000 pay cut and they're not paying you for another 3 months, they can be levied upon a 3 lakhs penalty, which will be payable to you. And very interesting part is that more in such provisions, appeal is very stringent. You need to pay 75% of the amount to the person before filing an appeal. So basically, the appellate provision is a redundant provision, which is very less opted for. But otherwise, what most of the industry standards they are practicing is that they are paying around 50 to 60% of the salaries and wages, and will be adjusting. Even the government are also deducting 30 to 60% of the pension and salaries of their workers, and they'll be paying the later part of the year, supposedly in a month or two, when the collection of taxes and collection government revenue increases. But certainly one thing is very sure, one thing is very straightforward, that no industry can deduct a pay wages without giving any justification, without implying any financial measures, because deducting a salary or deducting a wages is a financial censure, where there is a proceeding which has to be done by the department or the company or the work or the industry. So
Okay.
they cannot deduct your salary. They can delay it, but they cannot deduct it.
Okay. And in the work from home scenarios, this particular like question I have, I want to take it up with an example. Let's
Hmm.
suppose I'm working from home, and suddenly the ceiling fan, it falls on my head. Can I be compensated for the same?
Yes, you can. You can be.
And what are the
You-
what are the provisions in regards to that?
See, for that, you need to look into the Fatal Accidents Act and Claims Act. See, what happens is that the prerogative of that person is that he should be working for the company. It may be at the company's workplace, or it may be at the place of where the employer has decided you or made you to work. It can be on the streets also. So if you remember, there have been certain case laws and certain incidents where people have been working on roads and they have met with an accident, and there has been a temporary or a permanent disability. They will be compensated by the companies or the respective departments, because that is the workplace only. So the workplace is a very vague concept. It was first defined in the sexual prevention from the Sexual Harassment Act 2013. Before that, only your job perspective, only your job profile. Supposedly, you are working in the middle of a jungle, and it is your job duties to do that. And supposedly, a tree, you meet an accident, road accident, or a accident arising out of some natural calamity. So that will be within the four corners of your job duties, and you will be compensated for that. There has been I have even there were queries from employers to me also, that what will be the effect of work from home. Work from home doesn't mean that the person is not on the job. He is doing it on the job because of he's doing the job from his house because of the certain guidelines issued during the calamity. So at home also he's working. At home also he's performing his job duties. So that will be counted in his job duties only.
But how can this be fixed that the person was working only at his house when all of this incident has happened? There are no cameras or recordings or anything of that sort to prove that,
No,
right?
no, no. See, cameras and recordings, it can be done, but it is again in violation of your right to privacy. So
Right.
you cannot record your employee at home that what is he doing. So
Right.
that will be a breach of the privacy. But it is a case to case basis. It is a case to case discretion. Supposedly, I am talking to you, and supposedly I meet with an accident. So my talking to you is not my job duty. So that won't be considered in my job prerogatives or job discretions, and that won't be classified for compensation. But yes, as part of my job duties, if I was working for some firm and the firm has asked me to go on a webinar and discuss the issues of labor laws with people at large, and during that if I meet with an accident, yes,
Mhm.
it will be the within the prerogative of that of your job duties, and you will have to be compensated. So it is a
Okay.
case to case basis. There are no stringent or strict principles. There is no checkbox that you check these 5 points and you are eligible for any compensation. It is a case to case basis discretion, case to case basis thing which
Depends on
needs to
case to
be
case.
taken. Yes.
Okay. That there have been like the companies have been implementing software and all those things where they take screenshots every 5 minutes, 10 minutes from your, computers and the laptops that they have given you. And how much of that actually breaches your privacy and how much of that is actually allowed as per the law?
See, the proof of work is no ground in the law. Okay,
Hmm.
that is only to the satisfaction of your superior authority. Nothing less, nothing more. The
Okay.
law never prescribes you that in order to show that you are working from home, you need to send screenshots to your employer.
Hmm.
So, frankly
But
speaking, it
the
is only
employers have,
practice.
but specific employers have
Yes,
actually
there are
made
certain
compulsory
softwares
the
also in the
software.
market. There are certain softwares
Hmm.
also in the market which is installed in your computer, which tracks your time, tracks your the hours over which you have spent working for the company or for your industry or for your employer. But
Hmm.
there is under the law there is no discretion. So, and it will be obvious that the law, the most of the industrial laws were framed prior to independence or next 20 years after independence. So obviously they could not have put such an inclusive definition to the working hours and all. The law only prescribes about working hours, and that too there is a cap of maximum working hours. It says 9 hours a day, 48 hours a week. That will be all. It doesn't prescribe that that if you work for 1 hour, the industry will not be liable to pay or not pay, pay deduct do certain deductions or not allow you to pay something. So these are all industry practices. The law doesn't provide you to deduct any amount or deduct the wages. You have to people have large have to be be aware that the labor laws is a social welfare legislation. It is not a commercial legislation. So if it is a social welfare legislation, the benefits of people at large involved in that industry has to be looked into.
Right. So, what if the company doesn't have, let's say, for example, there is a company based out of, let's say, Nigeria, and they have a subsidiary company here in India.
Hmm.
Okay, and that's a very small company. Like even the subsidiary has like less than 50 employees.
Hmm.
And now, because of the COVID situation that has happened, the company is struggling for its financial reserves. It has no really financial reserves, and the businesses have also gone down. How
Hmm.
much of that can be like an excuse under the labor law? Like, let's say these people don't have sufficient amount of money or reserves to pay out the salaries for people, as well as they are facing challenges in their original, I mean, Nigeria also for their operations. So what can be the recourse on the side of these employers that are there?
See, the employer, again, for that, every person who's working under some management must have signed a employment contract, must have executed the terms of his employment. He has to look into the terms of employment. If the terms of employment states that, that there are deductions can be made, or, a pay cut can be done, or your salaries can be delayed, only then those salaries can be stopped or can be delayed. Otherwise, the labor law is totally silent on that. The law doesn't prescribes any safeguard to the employer to not pay. There is no conditions prerequisite which says that in these XYZ or ABC conditions the employer can delay the salaries, or they cannot refuse the salaries. There is no such deductions, or there is no such prerequisite conditions for that. Every employer is bound to pay his obligations toward the employee. So you have to. That is why you create a additional financial funds, or you safeguard it. But given to the situation that there is the company is incapable of paying, every industry have trade unions. Every industry, or every industry has their own unions, group of employees forming unions. The unions have their management, in the sense that the union is headed by a union leader. There are secretaries also, there will be a treasurer also. Those people, the Trade Unions Act 1926, those people have to be taken into confidence that that the labor should not agitate regarding this issue. And as and when the company's financial stability increases, the salaries will be paid out.
Right. And what happens, like, specific? Can you like specifically tell me about like prevention of sexual harassment, like its applicability? I mean, now that the people are working from home, how does the Prevention of Sexual Harassment Act work?
See, the Prevention of Sexual Harassment Act 2009, 2013 had its birth from the Vishaka judgment, 1997's Vishaka judgment, which had given certain guidelines on the prevention of sexual harassment at workplace. Now, if you the section 2, I think O or K is the provision which defines workplace. Workplace very specifically is defined that when a woman is traveling or working in regards to her work duties from any other place specified by the employer, that also will be workplace. So supposedly, if I'm working from home, and there are you're working from home, and there are 10 people on a conference, and there is some unacceptable remarks, or unacceptable behavior which has been shown on by any colleague. So the Prevention of Sexual Harassment at Workplace Act comes into picture. It will be equally applicable as if you were working at your workplace, or as if you were sitting in the employer's office and working. So it doesn't differentiate, and very importantly, the act has a very open or that it is very exclusive or not inclusive in nature, for the reason that the employer, it says that the person or women working, whether employed or not. So if a woman is there in your office, she might not be working directly under you, or she might not be working directly with the company. But if she's there at the workplace, and if there is some misbehavior which amounts to the violation of provisions of the act, so the Prevention of Sexual Harassment Act comes into picture. It is not that that you can shy away from your responsibility, saying that women is working from home, and therefore the provisions of the act is not applicable. Even the dwelling place or the houses are part of the act. It very clearly differentiates between workplace and dwelling place and houses. So by virtue of that, all these All, even the guest houses, they will be part of workplace only. And if there is any shortcomings in a behavior of a colleague or any person who's working with that women, it'll be equally liable under the act, even if that woman is working from home.
Okay. And the last question that I have from my side before we take up the questions from all the viewers, there've been a long list of questions that are there.
Yes, I see that couple
So
of questions
the last
popping up.
question that I have is that what happens to the attendance policy that are there? I mean, what happens to the work of HR managers in that case? Because a lot of places, like let's say for an example, a LPO, right? They have biometric systems and all of that, and people generally have to put their fingerprints to get inside the project rooms and work there, and then come out. So they have like a strict attendance policy that they follow. What happens to these organizations that work on these strict attendance policies? What happens to these attendance
If you
policies?
remember that there was an advisory issued by the central government which says that biometrics attendance should be avoided as far as possible.
Mm-hmm.
So the
But that's again
biometric,
an advisory, right?
yes, it is an advisory, and in certain states there have been specific directions
Mm-hmm.
issued in this regard, very specifically stating that biometrics should be avoided. See, initially, if you look into the history of Industrial Disputes Act or labor laws, there was no concept of biometrics. There was only the concept, or even today, the provisions exist that the register have to be maintained. Register of attendance has to be maintained.
Mm-hmm.
Now, since somebody is needed to maintain a register or somebody is needed to operate a biometric, most of the industries are shut down.
Mm-hmm.
Everybody is advised and directed by the management to work from home. Who will do that? Nobody is there to ensure your biometrics are taken into record on day-to-day basis. Nobody is there to see whether there is there is a register which is properly maintained. And most of the people I have spoken to in recent times have said that the attendance are being marked through WhatsApp, and the daily work performance or daily average work productivity is also seen. So by that, your attendance is being marked as normal as you were working in the establishment of the employer. So there is no particular guidelines which says in the current, though there are no particular guidelines which says that there will be no the biometrics or the register have to be very strictly maintained. These are procedural aspect which has to be relaxed given the current times of current tough times which we are facing. These are not these stringent penal provisions which has to be followed in its word. You can read between the lines. That is what I would suggest.
Right. So let's just begin with the list of questions that people have come across, and I will read it out to you, and then probably you can answer all of them. Right.
Sure.
Sir, discuss about the new four codes and its pros and cons. The question is from Prabhakar.
Yes. Hi, Prabhakaran. These four codes are scrapping the 44 to 51 old laws which have been persistent from 1923 to 2013. The last one being the Prevention of Sexual Harassment Act 2013. So they are all, I think, except Prevention of Sexual Harassment at Workplace, or might be that also be included, because all the wages code have been referred to the Standing Committee of the Parliament. They are scrapping it into the total four parts. They are bringing, I think, I have shortlisted that name also. They are bringing four new codes. First being the Code on Wages 2019. Second being the Labor Code on Industrial Relations. Third being the Labor Code on Social Security and Welfare. And fourth being the Occupational Health and Working Conditions 2019. By Code on Wages 2019, they'll be scrapping up Minimum Wages Act, Payment of Wages Act, Payment of Bonus Act, Equal Remuneration Act. By Labor Code on Industrial Relations, they'll be scrapping up Trade Unions Act, Industrial Employment Standing Orders Act, Industrial Dispute Act. By Labor Code on Social Security and Welfare, they'll be scrapping up 9 laws, of which major is Employee Compensation Act 1923, Maternity Benefits Act, Payment of Gratuity Act, Unorganized Worker Social Security Act 2008. Uh, Fourth being the Occupational Safety and Working Conditions Code 2019, by which the central government is proposing to scrap up 13 major laws, 13 laws of labor law, of which four main is Factories Act, Plantation Labor Act, Mines Act, Building and Construction Workers Act. So by they are basically making it a more practical. The government is making it to a more practical aspect, since now there were so many acts. Every statutory act has its own adjudicating bodies. So by combining these all the legislations into core legislation, the government is doing granting ease of business to the industries, and I would very definitely suggest that most of the registrations have to be redone. So there is a lot of future in labor laws, specifically when these new legislations will be promulgated and brought into the picture.
Right. Next question is from Divyesh, and he says, "What is the process to determine the fairness of a domestic inquiry?"
See, the domestic inquiry, you have to first see that what is the basis of domestic inquiry. Domestic inquiry gets its genesis from the Standing Orders of Industrial Dispute Standing Orders Act. Every person who is working under some industry or under some employer cannot be kicked out in the middle of the night to to face the wrath of the time. An employer has to be justified in its act, and employer has to justify his acts. So the domestic inquiry's basic principle is principle of natural justice, that the employee and the employer both are heard by a person, by a person who is neutral, or who is not biased by the employer and employee. May probably a third party, or probably a third person, or probably certain person who specializes in that, to determine who is actually wrong. So the only principle which is followed in a domestic inquiry is principles of natural justice.
Great. Please, the next question is from, please also can you discuss about the startup jobs and salaries? We have already answered this question, I think, with the question I put across to you.
Bharat Maheshwari, I have a question.
So,
I have a question around notice period and withdrawal of resignation by an employee.
I'll just read it out for you, Nitish, because I've been taking it from the beginning.
Sure.
So, the next question is from Manjunath. In construction industry, can you throw some light on the labor laws, since we see a lot of non-compliance and harassment of labor officers?
So in there have been for industries and for construction, except Maharashtra, the general laws, labor laws are applicable in Maharashtra. There is a specific act that provides safety for the construction workers. So if there is any violation of, say, now working hours, minimum wages, working conditions, basic essential conditions, you can always complain before the assistant labor commissioner, who will first try to conciliate between the employer and the employee. And if the conciliation proceedings fail, they can always always refer the dispute under Section 10 of Industrial Dispute Act to the concerned labor courts or assistant labor courts for adjudication under a time-bound manner.
Great. The next question is from Anil Kumar Mishra. How to start practicing T2 and T3 cities in labor? How to make the clients and our connections with us as a new lawyer? Like, how do you make connections as a new lawyer, and how do you start your practice in T2, T3 cities?
See, every
That's more relatable to you, I believe, Nitish.
Yes, since I being in the tier 2, it definitely is related to, I can answer that well. See, every city or every state has its employer associations or employee associations. You can always join these employer associations. Employer associations is basically an association of all the industries across the state or across the city who gather at one place. They are basically two parts of it: industrial members and professional members. So you can always become a professional member give your opinion to it. They conduct lot of webinars. They conduct lot of speeches and on an online exercise. For that, you can always join in and give your views, and that is how you normally make an industrial contact.
Great. So the next question is, how does the MHA notification, sorry, on 29th stand with the advisors? Would you be distinguishing it among them the advisories?
MHA notification,
Notification on
I think I'm
29th.
not sure. I'm not sure which notifications are you talking about. You can elaborate and send me a mail so that I can see and revert back to you. I am not aware which notifications you are particularly speaking about.
Maybe we can put in your email ID and for people to reach out to you for their personal questions if the same are not being answered here.
Yes, sure, no problem.
Okay. So the next question is from Arun. One more issue in construction industry is compliance under the BOCW Act,
Yes.
with specific reference to the considering supply and services to be included, which arriving at the cost of construction. The issue is still in the Supreme Court and no finality has been reached in this aspect. What are your suggestions?
We can wait for the orders of the Supreme Court. That is the best suggestion I can give you.
Right. So that's typically a lawyer doesn't answer before the Supreme Court. Actually answer the question.
I am bound by the judgments of the higher courts or Supreme Court. Let us wait for them to adjudicate, and then we can interpret it in either ways.
Right. Sir, one of the top businesses company, which is only Anil Kumar Mishra has this question. One of the top businesses company, which has only paid only 40% salary to the employees. And this case, how to be support to legal assistance to the client in both side, employer and employee. So I think we sufficiently answered this question in the discussion in the beginning, right? Then the question is from Arun. He says, what is your esteemed opinion in relation to practice in labor laws when the manufacturing activities in India is no more and only service industry is booming?
So that means there will be a boom as soon as the lockdown is open, because a lot of labor, I believe that the first thing the management or the industry will be doing is chucking out the dead wood. So get hold of those dead wood and you will be booming in your litigation.
Right. For Divyesh, we have already answered this question of domestic inquiry.
Yes.
And then there is Eamon Pardiwala. And this question is, what is the effect of force majeure on service industry? Are they bound to pay, say, for example, small firms or offices?
Yes, every employer is bound to pay. See, as I told you in my discussion, every person has an individual contract with the company. So the terms of the contract has to be strictly construed. It's a legal document which holds a complete sanctity in the eyes of law. So, given the scenario, you have to check with your employee with the contract. But nonetheless, wages or the salaries are the essentials of the job, and you have to be paid. There is no second thought that he can deduct your salaries or cannot refuse to pay you your salaries. For that, there are provisions under the law, under the Payment of Wages Act, under the Industrial Dispute Act, to raise the grievance before the concerned labor commissioners and labor court. And you will be awarded. You can get compensation ranging from 2 times to 10 times as a penalty upon the industry for not paying his dues.
Right. Then the next question is from Swati Ratna, and she says government is instructed to pay wages to all workers. How about piece rate workers?
How about
piece rate workers?
Who are they?
I don't know exactly what that means.
But nonetheless, the government has issued an advisory, and there are certain states which have issued specific directions, like particularly in Rajasthan. I think 2 days ago, they have issued a specific order directing they have issued particularly to the schools, educational institutes, that the salary of no teachers will be stopped. So in that condition, it's a very specific directions. Every state has passed its own directions. You have to check with your state notifications. If there is a very specific direction that the pay cuts cannot be made, that means pay cuts cannot be made. It is not to the discretion of the company to make it. You have all the legal remedies available in the law to file a case against the employer for wrongfully deducting your salary.
Great. Next question is from Lockdown Me. That's a very unique name. How should the software companies prevent labor litigation against themselves for mass layoffs?
See, 50% of the states do not have software companies. They do not consider software companies people as a labor. They are well-educated professionals. They are not in the category of labor. Particularly, specifically, if I talk about Northern India, I don't think, I am not sure of Haryana. Most of the states do not put in IT professionals or software companies employees as laborers. Yes, there are certain states in down south which have placed, I think, Tamil Nadu or Karnataka, which have placed software company employees as labor. So the provisions for resolution under the Industrial Dispute Act and under the Minimum Wages Act and under the Payment of Wages Act is applicable to you, and recourse under different authorities. Payment of wages prescribed by particular authority for adjudication, while the industrial disputes provide industrial tribunals and labor courts for adjudication. So that particular option is always open to you to access.
Right. So I believe it's already 5 p.m. now. We can extend it to 10-15 minutes more and try to answer as many questions as you can.
Sure.
Okay. So the next question is from Arun. What is your opinion on the labor inspector commencing frivolous criminal proceedings against the directors for non-compliance of the provision, sometimes with or without vested interest, because commencing the criminal proceedings is in the hands of the lowest authority, but withdrawal is not in their hands?
Yes, this is a particular lacuna which exists, that on finding some non-compliance, they can institute a criminal proceedings, as well as some financial measures can be adopted in an industry or against an employer. So I suggest that if there is a criminal aspect or criminal litigation initiated against you, opt for filing a quash petition or for appropriate remedy before the High Court, because there is no remedy other than that. Labor Department do not have the authority, do not have the power in the books to withdraw the criminal proceedings already initiated. It is for the prosecution department and for the High Court to demolish the case as and when on case to case basis.
Right. The next question is from PA. He says, what is the success rate for clients, employee, when they file a case against a company who did not pay salaries and laid off?
See, there is no success parameters. There is, as I told in my discussion, there is no checkbox. You check those 5 points and you win a case or you win a situation. It will be a case to case basis. But yes, since the labor law is a social welfare legislation, I very sincerely believe that the employees hold a major strength in these laws.
Right. The next question is from DJ Legal, but I don't think we have sufficient time to answer that. But I'll still read out the question. Can you please explain the concept of daily wages and monthly wages calculated on 26-day basis under Minimum Wages Act? Can you
It's a big concept. It will require another complete session. It cannot be answered in 10 minutes.
Right. So I move to the next question. That's from Jel Oda. And what about the provident fund claims and pension disbursement? How does EPFO ensure that?
See, pensions, the government, I believe that government has looking to the financial conditions of the state. Particularly in Rajasthan, I think there have been 30% cut in the pension. But that is not a cut. That is only that the pension has been stopped and will be paid in future. So I don't think that is an issue. Yes, if the EPF provident funds are not being deposited by the companies, you always have the recourse under the Act to raise before the concerned commissioners and the authorities to very specifically, raise a grievance that provident fund is not being deposited by the employer, and it is not a liability. It is no charity which they are doing. It is a bounden duty of the employer to do that. So the things will be taken to task.
Okay, the next question is from Shweta. Retired central government employees are getting pension after 30% pay cut without any direct information to them.
It's not a pay cut, it's only a delay in payments.
Next is, what if there is a justification, reasonable, but still affecting my salary or wages? Do I have my right to claim?
I'm sorry, I missed that question. Can you read it again?
What if there is a justification, reasonable, but still affecting my salary or wages? Do I waive my right to claim?
No, you do not waive your right to claim. But as you yourself are answering the question that there is a reasonable justification to that, then if there is a reasonable justification, you cannot argue against it.
So this is one question even I wanted to ask, but Bhargavi has asked here, what is the legality of amending employment agreements in the current scenario?
See, employment agreements is a two-way. It's a two-way process. When I say it's a two-way process, there's an employment agreement which has already been entered into. If the conditions have to be amended, then the consent of both the parties have to be accorded. It is not that the employer can amend the contract on his whole in its own discretion. Once the contract has been entered into and the employee is working, if there is any changes which are required, it has to be done with consent of both the parties. It is as good as a pure civil law.
So then there are next questions is from Nirmit. What happens in a situation wherein there is no employment contract and due to such lockdown situation, there is a pay cut or layoff? What is the remedy available to them?
First, you have to determine whether you are a labor under the labor law or not. If not, you have the remedy of filing a suit for damages against the employer. Supposedly, if you are within the notified labor definition, then you can raise the grievance before the payment of wages authority. And supposedly, even if then it is not paid, there is under Section 31 of the Industrial Disputes Act. You can definitely go for a criminal prosecution of the directors of the company.
Next question is from Anil Kumar Mishra. He says, during these days, retail companies have forced their employees to come to office or warehouse. In this situation, if the employee is being affected with COVID-19, can they get same benefits like government employees?
First, do not go call 100. That is the foremost requirement. No employer can force you to come down in the establishment and ask you to risk your life for working. Nonetheless, as I said in my discussion, whether you work at your home or you work at the establishment of the employer, if you are performing your job duties, you will be accorded all the benefits, which if for unforeseen reason there is any shortcomings, then the employer is liable to pay.
Okay.
Accidents or other provisions.
Next question is from Debasis Sinha. He says, can the faculty members of the university file a litigation for the pay cut under the Payment of Wages Act?
Teachers are not laborers and therefore they are not notified under the Payment of Wages Act. They have their educational tribunal for such recourse.
Then the next question is from Nikita. She says, you said that the employees whose pays have been cut during this time are entitled to be paid at some point. Can you please tell us how much time is the employer given to act on this, and where can we find literature on this if we want to read more on it?
See, the time this is not provided under the act that they can pay it within a period of 2 months or 3 months. The time has to be reasonable. If after 2 months, 3 months, or 6 months you believe that they are not going to pay you, file a case against the employer against in an appropriate hierarchy of law. Though there is no, under the statutory provisions, it doesn't define reasonable time.
So the next question is from Divyesh. So when a private company retrenches its employees, do they need to send any legal notice or pay the complete wages?
Though they can, if a private company is removing some of its employees under the employment contract, generally the provisions are pay them 1 month or 2 months salary and in advance, and give them a termination letter or a removal letter, so they can always be retrenched by giving them 1 month or 2 months salary.
Okay. The next question is from Bharat Maheshwari. He says, I have a question around notice period and withdrawal of resignation by an employee. Kindly unmute me to ask. I am really sorry I can't do that, but I definitely want Nitish to answer this for you.
You can mail me a question anytime.
So the government, while issuing advisories, have invoked epidemic diseases. Okay, let's just finish this for the time being. And in the end, I request all of you to please rate this webinar on a scale of 0 to 10, where 0 being the least satisfactory and 10 being the highest satisfaction. I am just putting the email ID. Nitish, can you please put down your email ID here?
I'll do that.
So again, like in the end, we at LawSikho have a course around labor and industrial laws where we deal with real life situations as exercises. And every week we give you 2 exercises to deal with. It's a 6 months course. In case anyone is interested, like in this time of COVID, they want to develop their practices around labor and industrial laws, feel free to get in touch with me. I put down my number, my email ID, and whatever is required, I'll be more than happy to help you all. So let's just call it off, and thank you everyone for being here and rating us for a good rating of over 8. Thank you and see you again.
Thank you.
Bye. Thank you, Nitish. Thank you.
Bye bye.